I'm Matt Bishar with NAREIT.com here in Washington, D.C. at the Marriott Marquis for the 2016 NAREIT REITWise Law, Accounting, and Finance Conference. Joining me today is Prentiss Feagles, partner with Hogan Lovells. Prentiss, thanks so much for joining us.
Happy to be here.
Now, can you start by discussing some of the provisions that were in the PATH Act, which was passed by Congress in December, that are going to have the biggest impact on the REIT industry?
There are actually several, I think. First, from the client point of view, they eliminated the preferential dividend rule for public REITs, which was an annoyance. It was a source of revenue for lawyers and accountants, and it was a nightmare for a company that got stuck in it. And there was no reason for it, and it's gone, and that's a good development. More substantively, foreign investors in real estate have always had a problem in the U.S. The so-called FIRPTA Act seeks to tax a lot of their investments in U.S. real estate. It's constrained investments in REITs, and the rules were liberalized, which were particularly beneficial for public REITs. I think the main areas of change that help a lot are historically, if a foreign investor was exempt from FIRPTA if they held less than 5% of the shares of a public REIT, that 5% has been increased to 10%. Practically, few investors in a REIT go over 10% anyway, but it's essentially freed them up to invest like other large institutional investors in REITs without worrying about being subject to FIRPTA. The second significant change, in my view, was, although the rule is complicated, a lot of things need to be sorted out by Treasury and the IRS as to what it means, is essentially to provide that qualified foreign pension funds can invest in REITs without being subject to FIRPTA, which of course is the way U.S. pension funds can invest in REITs. As I said, there are a lot of technical issues that need to be sorted out anytime you have something like that, but my sense is Treasury is reasonably receptive to this change and will work with the industry to answer the myriad of questions that are now coming out, depending on a particular country or organizational structure, but that's a net plus. And lastly, publicly traded foreign funds, where there's a good treaty that ensures tax reporting, and there's not a single ownership that exceeds 5%, can now invest in REITs without being subject to FIRPTA.
And in your opinion, what would you say is the most complex tax issue that your clients are having to deal with right now?
To the extent there's M&A ongoing, and this has been an issue over the years, but it continues to become more of a challenge. For REITs that operate in the UPREIT structure, you inevitably have limited partners who have deferred tax liabilities. Their interests may diverge from those of the public shareholders. In some cases, they have contractual rights. In other cases, they simply have significant influence of the company. Probably one of the most difficult transactions we handled this past year was for a residential property REIT where they had a significant number of investors. The company was going to go private and be bought by a fund. The fund couldn't deal with people that had to have deferred tax liabilities, and actually our client and the fund joined together to get UDR to come to the table, and UDR actually offered a tax-deferred currency, took a significant portion of the portfolio, and in essence split the company in a way that worked for the limited partners, worked for the shareholders, and worked for the private equity fund that was buying it out. But I think those deals are always the most hardest to do because of the competing interests between the public shareholders and limited partners.
And what impact will the SEC's no action letter facilitating Rule 144 sales of REIT shares have on the industry?
Yeah, and I'm a tax lawyer, so I'm going to give you a really high-level view here. The SEC lawyers could go chapter and verse. Plain and simply, historically, if a OP unit holder exchanged their shares for REIT shares, then in order to sell those shares, they either had to hold them for 6 months to qualify for the exemption under 144A, or alternatively, the company had to put up a registration statement. And inevitably, particularly for significant unit holders, there was huge pressure to put up a registration statement that involves costs, time, and there are windows of time when you can do that and not do it. So it was a cumbersome procedure. What the SEC agreed with was to essentially treat the 6-month clock that I referred to as starting to run when somebody acquired the OP units rather than when they exchanged for the REIT shares. And so almost all OP units are held for at least 6 months. So essentially they can be converted into REIT shares and the shares sold immediately under 144A without the need for a registration statement. So, plain and simply, it's made the company's life easier. There's not a protection lost. because the investors have essentially always had the same economic security all along. And so in essence, the government was responding by simplifying a process where in effect the protection wasn't needed that 144A offered.
Great. Prentiss, thank you so much for joining us.
Thanks for being here.
For more from REITWise 2016, be sure to visit REIT.com.